Several federal laws have been enacted to advance the employment of individuals with disabilities and to reduce discrimination based on a disability. These laws and regulations affect employment matters as well as public accessibility for individuals with disabilities. Disability discrimination is when a person with a disability is treated less favorably than a person without the disability in same or similar circumstances. The Rehabilitation Act was passed in 1973 and represents the earliest law regarding individuals with disabilities. The law applies only to federal contractors and requires them to take affirmative action to employ workers with disabilities based on steps outlined in the contractor's AAP. 2 decades after the passage of the first law prohibiting discrimination against individuals with disabilities, the Americans with Disabilities Act was enacted in 1990. The Act applies to private employers, employment agencies, and labor unions with 15 or more employees. It is enforced by the EEOC. In 2009, Congress passed amendments to the Americans with Disabilities Act, overruling several key cases and regulations and reflecting the original intent of the ADA. The effect was to significantly broaden the definition of individuals with disabilities and include anyone with a physical or mental impairment that substantially limits a major life function without regard for helpful effects of medication, prosthetics, hearing aids, and so on. This establishes a very low threshold for establishing whether an individual isn't disabled under the law. A 3-pronged test is used to determine whether an individual meets the definition of disabled. A person must meet one of the following 3 conditions as stated in the ADA and modified by the Americans with Disabilities Amendment Act. A person with a disability is someone who, 1, has a mental or physical challenge that greatly reduces the ability to perform important life functions, 2, possesses a record of such a challenge, or 3, is thought to have such a challenge. Discrimination is prohibited against individuals with disabilities who can perform essential job functions, that is, the fundamental job duties of the employment positions that those individuals hold or desire. These functions do not include marginal functions of the position. Qualified person with a disability, an employer must make a reasonable accommodation. This involves modifying a job or work environment to give that individual an equal employment opportunity to perform. EEOC guidelines encourage employers and individuals to work together to determine the appropriate reasonable accommodation, rather than simply employers alone making these judgments. Reasonable accommodation is limited to actions that do not place an undue hardship on the employer. An undue hardship occurs when making an accommodation for individuals with disability imposes a significant difficulty or expense on the employer. The ADA offers only general guidelines for determining when an accommodation becomes unreasonable and will create undue hardship for an employer. The ADA restricts employers' attempts to obtain and retain medical information related to applicants and employees. Restrictions include prohibiting employers from rejecting individuals because of a disability from asking job applicants any question about a current or past medical history until the conditional offer of employment is made. An additional ADA requirement is that all medical information be maintained in files separated from general personnel files. They must be stored in a secure location, and access should only be granted on a need-to-know basis. Prior to the Americans with Disabilities Act Amendment Act, employers won 90% of challenges regarding whether an individual actually had a disability. Now that argument is essentially moot. Companies no longer aggressively work to disqualify individuals from the status of disability.